Good afternoon and welcome to the latest webinar produced by intellectual property law firm Sterne Kessler, Goldstein & Fox. Today's topic is Are Software Patents Dead? What you need to know about Alice Corp v. CLS Bank, where we will discuss yesterday's Supreme Court decision. All lines have been placed in the listen-only mode. If you have a question during today's presentation, please submit it via the Q&A chat box located in the control panel on the right side of your webinar screen. If we do not have a chance to answer your question prior to the end of today's discussion, we will follow up directly to make sure you receive an answer. As I have already noted in the chat box, if you'd like to receive a PDF copy of today's presentation, please send an email request to Carrie Saracini. Today's presenters are Rob Sokohl, Jon Wright, Michelle Holoubek, and Jon Strang. At this point, it is my pleasure to turn the call over to Rob Sokohl.
Thank you. So, as many of you know, Alice, you mentioned Alice dealt with a computer-implemented scheme for mitigating settlement risk, i.e. the risk that only one party to a financial transaction will pay what it owes by using a third-party intermediary. In this particular invention, the computer was the third-party intermediary. What distinguished this case from other cases that came before, like P.L.L.C, was that there were method claims, system claims, and computer program product claims. In particular, the system claims included a computer, a communication interface, a memory, very hardware-oriented components. Just a little bit of background regarding the Federal Circuit decision. A 5-member plurality panel at the Federal Circuit held that all the claims were not patent eligible and applying Mayo. The majority of the court found that the method and computer program product claims were not patent eligible, and the Supreme Court granted certiorari. Now, what did the Alice Court say or suggest? Well, first, the test articulated in Mayo applies to abstract ideas. That is now crystal clear, thus providing some guidance on what test patentees, litigants should apply. The court reiterated that they must tread carefully in construing the abstract idea principle, lest it swallow all of patent law. That's certainly a criticism of Mayo in the past, and this case provides really no suggestion on how they're going to tread lightly, but nevertheless, this is the statement made. The court distinguished between building blocks of human ingenuity and those that integrate the building blocks into something more, thereby transforming them into a patent-eligible invention. Importantly, this case does not touch upon whether or not software per se is non-statutory. I think it's fairly clear from this opinion that software remains statutory subject matter, and more likely than not, this case will be limited to perhaps financial products or certainly business methods that are more abstract concept. They also said that stating an abstract idea while adding the words apply it is not enough for patent eligibility. This is, of course, citing to Mayo. Also, the mere recitation of a generic computer cannot transform a patent-eligible abstract idea into a patent-eligible invention. This is probably the first time the Supreme Court has really gone this far, though you could argue Benson suggested this as well. But this was an important point in this case, given the fact that we have system claims, and the system claims having a computer as well as the memory and the interface was not sufficient to turn the otherwise abstract idea into a patent-eligible invention. And finally, if you look at the concurring opinion, you'll see that Justice Sotomayor, Ginsburg, and Breyer would have found that claims merely describe a business method are not statutory. The remainder of the court did not join in that, and therefore patents can still be obtained for business methods. What this decision did not say, it did not provide any definition for abstract idea. In fact, Justice Thomas said, the court stated, we need not labor to limit the precise contours of the abstract ideas category in this case. In fact, they just refused to provide a definition, saying essentially that the abstract idea in this case was similar to the abstract idea in P.L.L.C, and it was therefore pretty clear there was an abstract idea and didn't need to go further.
So if we look at what this means for the Patent Office and what it means for practitioners who are patenting or trying to obtain patents from the Patent Office, as well as for patentees who already have patents that may be affected by this decision, we wanted to walk through maybe some practical takeaways and things that you can do in light of this decision. As Rob mentioned, this decision really relied heavily on Mayo, and so from that perspective, there's not a whole lot of new information that the Alice decision offered over what we technically knew from Pty and from Mayo. And it did certainly crystallize a few things, and one is that application of the two-step test in Mayo to software claims. And as Rob also mentioned, recitation of a computer, if that's just added to an otherwise unpatentable method claim, that's not going to be sufficient to remove it from the grasp of the Alice decision. So what can patent applicants and patentees do with their existing software cases to try and inoculate them from falling into the same category as Alice did? Well, of course, starting with the claims, that's where the key issue is going to be. And all this talk of abstract idea just leads to the thought that you really need to have as much detail as possible to try and distinguish your claims. But that has to be strategic. Right now, in front of the Patent Office, and it remains to be seen what the PTO guidelines, if they issue new guidelines, what they will look like. Presumably they would issue new guidelines, but will they look drastically different from the interim guidelines that were instituted after Pty or those that came after Mayo? It's unclear there. Right now, it's a common practice at the Patent Office for examiners to suggest, in order to overcome a 101 rejection on method claims, adding some language along the lines of implemented on a processor, or wherein a particular step is performed by a processor or a computing device, things like that. And I think the question that you have to ask yourself is, even if that's enough, and if that remains to be enough to overcome a 101 rejection at the Patent Office, is that going to be enough to maintain the value of the patent down the road if you ever want to enforce it? Are courts going to have the same standard of deciding patent eligibility that the Patent Office does? Looking at the Alice decision and its clear language that recitation of a generic computer isn't going to be enough, it leads me to believe that the current practice of adding in a computer may be sufficient to get over the Patent Office rules. It may not be sufficient to keep your claims viable once they enter litigation in front of the district court. So, as much detail as you can possibly add into a case or into a claim would be useful here. Again, I also mentioned strategically from the perspective of adding limitations that are conventional or that are common sense. Just adding limitations for bulk are probably not going to be the things that are going to add value. You really have to think about what is it that makes this particular claim technological in nature. What from your specification can you look to show that this claim is technological versus non-technological? In the Alice decision, the court refers to this idea of a technological process, and things that are considered patent eligible have taken a technological process and improved upon it. So maybe one place to start there is to identify, well, what is it that's technological? Obviously, the court here doesn't define abstract. They don't define technological. They don't really mention business methods except for in the final, in the concurring opinion. But that may be one approach, is to really try and highlight what the technological component is and add the detail in the claims on that particular component. in patent applications, they need to support the claims in similar detail. You really need to identify, maybe, don't be afraid to talk about the prior art or what was conventionally done, because it seems like this is now part of the 101 analysis. The court is looking to what steps were conventional, what steps would have been common sense to someone in a particular industry, and if those are the steps that are recited in the claims, the court is finding that those don't add any significant limitations, at least no patent eligible limitations to the claims. So perhaps it makes sense to talk about in the background, or at least in trying to distinguish yourself and in identifying what the novelty is, identify what the technological processes are that have failings, and then how your invention purports to solve those problems. Both of those are on the drafting side. Certainly, if you have a patent application that's already been filed, there's not much you can do to add support to the specification. But in prosecution, you still use what information is in your specification to respond to a 101 rejection. And again, think about the differences between what will be sufficient for this examiner versus what will be sufficient long-term. And so maybe in response to the 101 rejection, address differences over convention, address differences over common sense. And then the depth and the quality of spec will also be really important here. Once a patent is issued, obviously now we have PTO litigation to deal with as well. And CBM, I think, is an obvious place where this decision is quite relevant. Section 101 was already a ground of unpatentability that could be used to support a CBM petition. And I think this decision just emboldens petitioners' use of that in the sense that if you had any hesitation on using 101 because you weren't sure of what the Alice decision would say, well, Alice has come out, and if there's a software claim or a business method, then I think there's language in there that will support it. Interestingly enough, and this could be because the Alice decision doesn't equivocally come down with any sort of definitions one way or the other, there's also language that can help patent owners as well as helping those who are challenging patents. The court's seeming focus on technological process kind of ties into the CBM requirement that a patent reciting a technological invention is exempt from CBM. The court here did not define what it means to be technological. There's a question of whether the PTO has defined clearly what it means to be technological. But if you're having to make arguments about why the patent is a technological invention, those play hand in hand with 101 analysis. So you may be able to overlap there and address it from the same way. There's certainly language, as I mentioned in the decision, to go either way, that can help both the petitioners and patent owners here. Supplemental exam is another place that patent owners may think of for quote-unquote fixing issued patents that might have a 101 problem. We typically think of supplemental examination as being for patents and printed publications, but in fact that's not the case. The way that supplemental exam works, as I'm sure many of you are familiar, this essentially a patent owner requests that it be reviewed. You have to provide certain reasons as to why the patent needs to be reviewed. The patent office will turn a decision around in 3 months, and if they decide that yes, a substantial new question of patentability was identified in the supplemental examination, they'll institute an ex parte re-exam. That institution of ex parte re-exam may be what leads people to believe that, well, this is relevant to patents and printed publications, but if the ex parte re-exam is instituted from supplemental exam, the rules regarding patents and printed publications don't actually apply. So the Patent Office has confirmed that you can raise a 101 issue in your supplemental exam, and if they institute ex parte re-exam, you can address 101 issues there. And again, going back to our previous slide where we talked about what you can do with claims, maybe different ways that you can try and amend those claims to include some more detail or focus more on the technological components of the invention, that may be a possibility for supplemental examination. So those are just a few of the options available at the Patent Office.
I would just add, I think preemption is the key. Preemption was argued, of course, before the Supreme Court, but the key is to identify what the abstract idea is, and then to draft your claim so that you're not preempting that abstract idea. That's easier said than done, but that really is the thrust of what's happening here. I think the Supreme Court felt that the quote-unquote abstract idea was preempting intermediary settlement and therefore was insufficient. So the goal is detail matters.
Right, and sometimes we're quite loath as patent prosecutors to really dig into the details and identify certain things. But in this case, it may be useful if you have something that's likely where 101 is likely to be an issue. Don't be afraid of addressing it. Take the offensive. Define, maybe in your spec if you're drafting a new application, what the field is here, what the general idea is, and then try and build into that how the claims are maybe a particular implementation of that.
To add on a little bit to what Michelle and Rob just said, if you look at Judge Lori's concurring opinion in Ultramercial after it was GVR'd from the Supreme Court for the Federal Circuit to look at it again after Mayo, Judge Lori did speak on that issue about how the claims in Ultramercial were more than just the abstract idea, and they went beyond that. Continuing on to, if you're already before the district court as a defendant or a plaintiff, again going back to Michelle, even if your case has been going on for a while and you have inter-parties re-exams or inter-parties reviews ongoing before the Patent Office, you might want to consider filing a covered business method review under 101, or don't forget you have Nautilus out there. Now, if you're a defendant, the first thing you've got to think is, do you already have coverage in your invalidity contentions? Claims 1, 2, and 3 were asserted, and you go back and you look at your invalidity contentions that were written before Nautilus and written before Alice. You're thinking you may have only alleged that, or you may have only contended that Claim 1 is invalid under 101 and 112. You need to immediately look at getting leave to amend your contentions if you're in a district court that requires the court's leave. Ask the other side for permission. Depending on who you're litigating against, they might say no. And the clock is ticking. You don't want the other side to be able to argue prejudice. Now, the court will apply the law, but the question is whether or not you can apply the law as to those claims. So make sure you get your invalidity contentions amended or ask for leave to amend if you're at that stage. And, of course, you're going to argue all this on as early as motions to dismiss. We are seeing more 12b6 motions to dismiss under 101, and I think with Nautilus and now Alice there, I think that's a prime opportunity to get rid of a case early if you're a defendant. On the other hand, if you're a plaintiff, be ready, expect to see that motion for leave to amend, and if you want to oppose and you think you have grounds to oppose, you should oppose it to limit the amount of damage the defendant can do to your claims and the amount of cost they can inflict on you. But key, and I think this is already hit on by Rob and Michelle, is framing of the issue. Go to the next slide, Rob. When you do argue this, you have to look at how the issue is framed. Now, in Alice, they applied the two-step Mayo analysis very clearly, or in a very clear fashion on how to do that. Step 1 being determine whether the claims fall into a patent ineligible concept such as abstract subject matter. And you look at the losing patents, the patents that have lost on 101, there was always a clear, crisp statement of the abstract idea. Myriad was one of my favorites. The challenger said, Myriad said, are human genes patentable? And if you've read that case, you know it was about a lot more than that. But just putting that question right out there, are human genes patentable? Pty, they summed it up as saying, the patent's only about hedging risk. And Alice, all the patent does is intermediated settlement. I know Rob, who was on the briefs on that, feels very strongly the patent did a lot more than that, but that's how the framing the issue gets very important. And Benson, the same thing. If you've ever read the claims in Benson, you know it was actually a pretty nifty method of using a reentrant shift register to convert binary coded decimal to binary. But they framed it as just merely an algorithm for converting BCD to binary. And that crisp statement, it carries the theme through the case. And as a defendant challenging a patent, if you get that good, short, crisp statement, that flows nicely into the second step of the Mayo analysis, which is basically showing everything else is generic and well-known. And I think Alice, you can see Alice how they just march right through there, and it all falls away at that point. Now, if you're the plaintiff, you're on the other end of that. And you have to say that the defendant's characterization is grossly oversimplifies what your claim is actually covering. And again, I point back to Ultramercial with Lori's concurrence after it came back from Mayo. He said it's more than just using advertising as an exchange of currency. And he clearly said, he came out and expressly said, it's not because the computer does this. It has to do with what the claims required. And that the computer was involved was not part of his analysis.
If I can interject there, I mean, that was another theme throughout Alice, is that they essentially stripped away the computer implementation of Alice and focused in, okay, when we don't have the computer and when we don't consider what the computer is doing, what are we left with?
And that's exactly right. And it really comes down, I hate to say it over and over, but framing the issue, it's really become a lawyer's game. And to some extent, you're going to be trapped by what are the preconceptions your judge has. And if you think back to what Michelle said earlier about drafting the patent and drafting the claims, as a patent owner, as the plaintiff, you need to have a story of what your invention is, that there really is something inventive here, and get the judge emotionally involved so that he or she believes in their heart that you have an invention and doesn't want to find against you. And I think that's really the tough part, and I think that's, you know, as Michelle led to earlier, is the claims have to be there, but the fact that there's some sort of invention there is going to show up in the spec. And it also goes into the technological process. That's showing that there's an invention. The next step after that would be appeal. So, John?
Sure. So I'll now discuss the impact that Alice may have at the Federal Circuit. I'll start with some procedural aspects. If briefing is already in progress at the Federal Circuit and Section 101 is an issue that you've raised on appeal, then you obviously have to work the Alice case into your briefs. If there were no 101 issues below and you haven't raised them on appeal, then you can't do that for the first time, even in view of the Alice case. If your briefing is complete, the Federal Rules of Appellate Procedure and the local Federal Circuit rules both allow parties to deal with citation of supplemental authorities. When new cases come out, you can promptly advise the clerk of the court by a letter, with a copy to all parties, of course, that sets forth the citation. You have to say why you are bringing the case to the attention of the court and refer specifically to the page of the brief that's relevant. And keep in mind the body of this letter, the rules say cannot exceed 350 words. So it really has to be a concise statement of why the case is applicable. And keep in mind that your opponent can respond similarly with a letter to the court. And even if oral argument is complete, Rules 28J and 28I still apply. You can, instead of or in addition to citing to a page of the brief where you've addressed 101, you can point to where the 101 was argued orally. And you can do that by referencing a time mark in the MPEG of the oral argument that the court puts out. So substantively, we think that results at the Federal Circuit are still likely to be panel dependent. And this, the judges on the Federal Circuit are going to have to figure out how to tread carefully in construing Alice. As we've discussed, the court issued a fairly narrow decision that was limited to the facts of the Alice case, we think, and basically made it clear that the analysis set forth in Mayo v. Prometheus can be applied outside of the diagnostic drug testing field and applied more broadly in patents like Alice's patents. So the two cases that immediately came to our team's mind were the Ultramercial v. Hulu case and then the CyberSource v. Retail Decisions case. Both of those were 2011 cases. And, you know, Alice arguably perhaps makes Ultramercial a little bit weaker and CyberSource a little bit stronger, but let's just discuss those two cases very briefly. In Ultramercial v. Hulu, I think as Michelle and John have both noted, that was a way of using advertising as a form of currency, and the court there said that that is an age-old idea, but the patent at issue goes beyond that and identifies very specific steps on how to monetize copyrighted products. Those steps are set out in the claims. They involve complex computer programming, and the court concluded that, you know, viewing the subject matter as a whole, the invention involves a very extensive computer interface. And layered on top of the Ultramercial decision was a broader confirmation that software is patentable and that the digital computer and improvements to the digital computer through interchangeable software or hardware enhancements do deserve patent protection. Now, did Alice disturb that? We don't think that Alice disturbed that. Again, Alice was narrow on its facts. So, and to note, Ultramercial was Rader, Lurie, and O'Malley. CyberSource came out the other way with a panel of Bryson, Dyke, and Prost. And I think, Rob, correct me if I'm wrong, but this is kind of the way that the decision in Alice at the Federal Circuit kind of shook out as well, right?
That is correct, other than Lurie, who seemed to flip between Ultramercial and Alice.
Right. So in CyberSource, the Federal Circuit came out the other way. That dealt with a method of verifying a credit card transaction over the Internet. And there, that panel found that that was an unpatentable process. And they distinguished Ultramercial, recognized that there was tension there, and distinguished Ultramercial by drawing a line between purely mental steps versus computer-required steps. So what I wanted to pose to Rob was, do you think that the claims or that the invention in Alice required a computer to implement that?
The short answer is yes, and it was argued that the computer was in fact critical to the process, to the business method, because in order to do this in real time with multiple parties, it needs to be done by a computer. It just could not be done by an individual. Now, with that said, it wasn't addressed by the Supreme Court, that argument, and therefore it will go down in the lore of the case. But ultimately, yes, it was an important distinguishing feature, we believe.
So arguably, I think the CyberSource case perhaps gets strengthened a bit by Alice if you go back and dig into the claims at issue in Alice. But unfortunately, as Rob said, I think a lot of commenters have noted that the Alice decision is very short and very narrow. So, you know, some of that may be, as Rob said, lost to lore. So kind of to sum up the substantive impact, we think it'll, at least for a while, continue to be panel dependent. There are going to have to be a body of cases that will evolve, that interpret this abstract idea and apply Mayo. And that's how the case law will develop unless the court decides on its own or through petition to have an en banc decision.
John, can I add one thing on, excuse me, on Ultramercial? kind of an interesting story there is that was originally decided before Mayo, and Judge Lori, of course, was the drafter of the Myriad case. And so when Mayo came back down, Judge Lori's concurrence in the post-GVR ultramercial took Mayo into consideration, and he expressly said under an analysis under Mayo, whether there was a computer involved didn't matter for those claims. It's very, very fascinating to see Judge Lori on each side of the issue post-Mayo.
Which cuts directly back to our initial point that substantively we think there's going to be a fair amount of panel dependency, unfortunately, when these cases come before the Federal Circuit.
I mean, I think ultimately the Supreme Court didn't help the Federal Circuit with this decision, other than clearly indicating, as Judge Lori stated in his opinion in the en banc decision, that Mayo does apply to software and to abstract ideas, and that's probably the biggest takeaway here in regard to this case. Again, during litigation, frame the issue. I think defining what the abstract idea is the critical critical path in this this process of deciding whether a claim is patent eligible or patent ineligible. I think really it's very important to prepare a quality, detailed patent application when you're dealing with this type of subject matter. The more detail, the better. Everything that you can build into your application that distinguishes your application from what was known before, and almost to have the patent attorney start thinking about how is this going to be framed as an abstract idea, and try to think about, well, what details distinguish us from the abstract idea so it's not preempting that abstract idea would be critical.
And another reason that that's going to be really important is thinking about patent long term, and the description you write today is going to matter for the next 20 years. There's a lot of things that the Alice decision left undecided, and we could be in the same position 5 years from now, because as Jon just mentioned, what happens at the Federal Circuit is likely to be very panel dependent. There's a lot of types of software that we haven't talked about. You know, these decisions, you know, the Alice decision, the Pty Ltd decision, CyberSource, these are all financial methods. And so there's still a question out there, is what does it take to be technological? Where's the dividing line there? And since we don't know where that dividing line is, it's best to be prepared so that wherever it ends up being, you have support in your specification to be able to amend your claims as necessary, or make that argument as necessary.
And finally, computers are simply not enough to save a claim. If it's just a generic computer and all you're doing is processing your abstract idea on the computer, for example, processing equals MC squared on your computer, the fact that you recited a computer isn't going to be sufficient. And that was essentially what the court held here.
Sterne Kessler appreciates your participation in today's presentation. You are welcome to disconnect your line now. Thank you.